Before you assume that your LLC protects your house, your bank accounts, and all your personal assets, you really need to understand where that protection starts and where it stops. Your LLC is not a force field. It protects you from some risks and liabilities, but it's not a catch-all. You need to know how to protect yourself. A business owner thinks that their LLC protects everything, then a lawsuit shows up with their personal name on it. That's when the real panic starts. Business owner thinks that the LLC protects everything that they've got. Then a lawsuit shows up with their personal name on it, and that's where the real education starts. Your biggest LLC formation mistake is that you think that the business formation is the finish line, when in fact, that's actually the starting point. My name is Dustin Lee. I'm the owner and founding attorney of Ascend Legal Solutions, a business law firm in Texas. Everything in this video is for educational and informational purposes only. Nothing in this video is going to be considered business advice, tax advice, legal advice, securities advice, or any other type of advice. If you need advice about your particular situation, you need to contact an experienced professional in your area. Nothing in this video creates an attorney-client relationship. In this video, you're going to get a very clear breakdown of when an LLC actually protects the owner, when it might not, and the types of mistakes that create personal exposure without necessarily turning this into like a law school lecture. And if you stay to the end, you'll know how to think about whether or not you and your business may be exposed to risk, or whether your personal assets may be exposed to risk. And I'm not going to turn it into a law school lecture. So if you stay to the end, you'll know how to think about whether your business may be protecting you or not, and potentially what things need to be done to remedy that. So really quick, what are we going to be talking about today? First, what does an LLC actually do? Because a lot of people think that it does a lot more than it really does. Second, we're going to talk about the difference between you getting sued personally and the business getting sued and how that's meaningful for you. Third, we're going to talk about personal guarantees, which is where a lot of business owners give away that liability protection that they have with their LLC. Fourth, we're going to talk about how the LLC doesn't usually protect for bad acts of your own conduct. So if you're conducting fraudulent acts, the LLC is probably not going to save you. Fifth, we're going to talk about the commingling of business funds and personal funds and what happens if you do. Finally, we're going to take a look at what to do now to take action before there's a crisis and before a lawsuit shows up on your doorstep. So an LLC is designed to separate the business from the owner, but it does not make the owner untouchable. So if you're just a total beginner here, what is an LLC and what does it do? Well, an LLC is a type of business entity that you form with usually the Secretary of State or the state that you're in. And really the whole goal of having a business entity is to protect yourself from personal liability. So what's the purpose of that? You don't want your personal home, your personal bank account, your personal assets on the line if there is something that happens with your business. So you can form an LLC or potentially a different business type to protect those personal assets and have a liability shield that protects you. So the LLC is supposed to create this separation between business and owner. The owner is the member of the business if the business is an LLC, and essentially the owner can get the flow through of the profits without exposing the owner to the potential liability for operating the business. And the business is a separate, legal, distinct entity. It has its own obligations, it has its own rights, it has its own assets, it has its own liabilities, just like you personally have your own obligations, rights, assets, and liabilities. Now, general rule of thumb under Texas law and most states' law is that the members, the owners of the LLC, are not liable for the liabilities or the debts of the company. And that can include all different types of debts, whether it be contracts, lawsuits, you name it. So let's give you a real world example. Let's say your LLC signs a contract with a vendor that does not contain a personal guarantee. Now, let's say the LLC, for some reason, is starting to have cash flow problems and they can't pay the vendor. Now, at that point, as long as you've done everything correctly, the LLC protects the assets of the individual owner, meaning the vendor can't just hop over the LLC and sue the owner personally. However, really critical distinction here, the LLC is not unlimited protection. There are things that you can do as the owner that jeopardize that liability protection and could end up with a personal liability lawsuit with your name on it. So short story here, folks, the LLC is protection, but it's not a magic trick. So oftentimes the first question is not, can someone sue me, but really, who can they sue? Business owners will often ask, hey, can they sue me personally on this thing? There's a lot of nuance to the answer to that question. And as most people know at this point, you can be sued for anything at any time, anywhere, but that doesn't mean that you actually are going to be held liable or have to pay out any damages. You very well might win the lawsuit. But there are certain things that you can do that jeopardize your personal assets and can put that liability shield at risk. So, just as a general rule of thumb, if it's for conduct or activity of the LLC, usually the LLC is the proper party to that lawsuit. And if it's about the conduct or something the owner did or something the owner signed, then the owner may be brought into the lawsuit. So, for example, if the owner signed a personal guarantee or the owner used the LLC to perpetrate a fraud on someone, then at that point, owner's probably getting hauled in. So circling back to our vendor contract example, in this case, let's say you've got a company, ABC Company, signs a contract with a vendor. And at the bottom of that contract, you sign as the manager or as the president of ABC Company. The contract is for the operation or for the vendor account for ABC Company. You didn't sign a personal guarantee, and this is a legitimate business transaction in which you're trying to use this vendor to grow your company. In that case, it's pretty clear it should stick with the company and not the owner. However, on the flip side, if the owner of ABC Company signs a personal guarantee, well, at that point, now they're probably on the hook for the lawsuit. Likewise, if the owner of the LLC just intended to use the LLC to perpetrate a fraud on this vendor to get this vendor's services or materials and then not actually pay for them, then at that point, owner's probably getting brought in. Now, the Texas Business Organizations Code and other Texas law is pretty clear about when an owner can or cannot be hauled in on a personal liability claim. Now, one of the big examples there is for fraud. If you use the entity to perpetrate a fraud, you're probably getting hauled in. However, that means that under most normal circumstances, normal business operation, without a personal guarantee, without fraud, the LLC liability shield should protect the owner in most cases. Now, it doesn't make you invincible, doesn't put you out of the reach of everything, and it doesn't put you out of reach of getting sued for a bad reason or no reason at all because people are very litigious. But it does mean that if that does happen, you potentially have a really good defense. So, short story here, a lawsuit against your company and a lawsuit against you are very different things. Lawsuit against your company is a big problem, and a lawsuit against you, potentially, even bigger problem. The fastest way to lose your LLC protection is to actually sign it away. So, what is a personal guarantee? Personal guarantee is a document that you usually sign. It can be separate as part of a document package, or it can be together in a main document like a contract or a lease, where you are signing to be personally responsible for the debts or obligations of your entity. We often see this in credit arrangements, like if you're getting a loan for your business, or leases like commercial leases. You'll often see the owners signing a personal guarantee that the company will pay its rent and other charges due under the lease. So what are some situations where this can pop up so you can be aware? Oftentimes in business, we'll see this, like I said, in commercial leases, in financing for business loans. That could be equipment loans, business loans, credit apps, sometimes vendor accounts, though that's less frequent. Franchise agreements, purchase and sale agreements, things like that. You're often going to see personal guarantees being required. So the LLC still exists and it still provides liability protection for the owner for other things. But if you have signed a personal guarantee, you are personally guaranteeing the payment or the obligations of the LLC. And there actually can be some distinctions in the language of the personal guarantee, depending on what you're signing. Some of these personal guarantees can require the creditor to go after your LLC first, and some of them allow them to bring in you at the same time as the LLC so that they don't have to sue the LLC and get a judgment and then sue you personally. They litigate everything in the same lawsuit. So there can actually be some variation in the type or the procedure that you can see under a personal guarantee. Okay, so how about a real world example? Let's say ABC Company needs a physical space, so they're going to lease a space. They're going to sign a commercial lease, so you've got the normal commercial lease terms that get signed, and at the end, the landlord says, oh, I need a personal guarantee. So now the owner or owners of the LLC, of ABC Company, now sign a personal guarantee. Well, what happens if ABC Company doesn't pay the rent or the other charges that are due under that commercial lease? Well, now the landlord has the right to collect from the LLC, but also has the right to collect from the owners. And depending on how the personal guarantee is drafted, they may just sue the owners outright if the LLC doesn't have any assets. I'll tell you, a lot of times people will come into my office and they will have just glanced over the personal guarantee or they've said, all right, well, it's just the cost of doing business, and they don't really pay attention to it, and they don't know really how meaningful it is, that we can be really exposed to a lot of risk by signing one of those. So, practical education point, look out for words like guarantor, personal guarantee, jointly and severally liable, or in your individual capacity, or even a signature block that doesn't just purport to be a corporate signature block. If it includes you individually or includes your own individual name, either combined or as a separate signature block. The moral of the story here is that the LLC can't protect you from promises and contracts that you personally make. So an LLC can protect you from company debt, but it's not going to protect you from actions that you take. So, for example, your personal guarantee or also fraud. Now, we touched on it a little bit before, but in general, the Texas Business Organizations Code allows for the owners of the LLC to have liability protection or liability shield to make sure that the debts of the company and the obligations of the company don't come back on the owners. There is, in both case law, statutory, in a lot of states, and each state is a little bit different in how they approach it. There's going to be some ways to hop over the LLC and sue the owner personally if they've done something fraudulent, or if they've used the company to perpetrate a fraud, to trick somebody, steal money, things like that. A lot of states do have the ability to do that. A lot of states call it piercing the corporate veil. In Texas, we actually have a statute that talks about it in the Business Organizations Code, the ways that you potentially could lose that liability shield. And the main one being if you use the company to perpetrate a fraud. So if you personally commit a wrongful act, the LLC is not going to be a get out of jail free card for you. So the main thing that we're thinking about here with fraudulent conduct of an owner is whenever the owner, through the LLC, makes statements that are just completely untrue. For example, if the owner of the LLC said, hey, if you pay me $150,000, we can build your house by tomorrow. And then you pay them $150,000 and, oh, look at that. They didn't build your house by tomorrow. They never intended to build your house by tomorrow. In that situation, you're looking at potentially being able to jump over the LLC and sue the owner personally because of the fraud that they committed. And what happens a lot of times is if you are out there representing the company as the owner, you can kind of blur the lines between I'm doing this versus the company is doing this. So it's really important to phrase things in a way and to present things in a way that everything is going through your company. And then obviously don't do fraud. So at the end of the day, the LLC protects the owner from a lot of things, but it's not a get out of jail free card. If you treat your LLC's bank account like it's your personal wallet, don't be surprised when a creditor jumps over the LLC and comes after your personal wallet. So what's the issue here? The LLC is supposed to provide separation between the owner and the company. That means separate bank accounts, separate assets, separate liabilities, separate contracts, separate everything. It is a completely legally distinct entity from the owner. And when you start blurring those lines, that's where things can become problematic. So what are some of the big red flags here? Well, the biggest one is paying personal expenses out of your business bank account. So let's say you decided you're going to go on vacation this week and you're going to go hop over and take a nice vacation with your family. You're going to put it all on your business card because you get to expense it. Well, surprise, if you didn't do any business on that trip, that's just a personal expense you paid out of your business account and you're now commingling funds. Another big issue can be paying business expenses out of your personal account and then not properly accounting for that in the business's records, either with some sort of reimbursement or some sort of bookkeeping entries. Obviously, signing contracts in your own name, using inconsistent business names, having no clear documentation, all of these are problems as well. But the one that I see most commonly is people that are paying personal expenses out of their business account. Now in Texas, commingling of accounts alone may not be enough to put you on the hook with respect to your creditors. Now, that's not going to say anything with respect to the IRS, good luck there. But with respect to any particular creditor, commingling of accounts may not be enough, but I wouldn't risk it. Essentially, sloppy operations create bad facts, confusion, tax issues, and any number of other things that may pop up that make you look bad either in the litigation with your vendor or your contractor, but also, don't make the IRS mad. If you remember one thing from this video, just remember the LLC does provide a great liability shield, but it is not perfect. the way that you operate the business, the way that you conduct yourself, the things that you do when you're operating the business also are extremely important for maintaining that personal liability protection. Thank you all for watching. If you like the content, please subscribe to the channel and head over to the website to check us out.